item number 30, WPC 6743 2024.
Impugn order of the NCDRC is then set aside in quast. Matter remanded
To Family Court, Kamrup Metro, my lord. The petitioner filed in one divorce petition at District Judge Sibsagar, which is numbered as 142 of 2025, my lord. And this lady, my lord, he is staying here and he is working in a temporary basis at Joraba. So she is also, my lord, 50% physical disorder, suffering from orthopedical physical disorder. That is annexure 4, my lord, page 23, my lord. That is the certificate, identity card issued by the. And in this case, my lord, both the persons, they got married at Nogao. They got their registered marriage at Nogao as well as performed their social marriage at Nogao also. My lord, now this case is filed at Sibsagar, my lord, hiding these things before the court below me.
Okay, let notice go at this.
My lord.
Let notice go.
Yes, my lord. In the meantime, my lord, the interim protection. Otherwise, the matter may be goes expertly against the petitioner.
Heard, Mr. What is your name?
NC Dutt.
Learned counsel for the petitioner. This petition under section 24 of the 24. Read with section 151 of the Code of Civil Procedure is prepared by the petitioner for transferring of TSM case number 142 of 2025 pending before the Court of Learned District Judge Sibsagar to the Court of Learned Principal Judge Family Court Kamrup M, Gauhati. Mr. Das, learned counsel for the petitioner, submits that the petitioner is the wife of the respondent wife of the sole respondent who has instituted the title suit. M case number 142 of 2025 before the Court of Learned District Judge at Sibsagar for dissolution of their marriage. Mr. Das further submits that the petitioner is presently residing at Gauhati and she has been doing a job at Zorabat.
At Zorabat, temporary basis in a food processing
Gauhati
company.
on temporary basis, and besides, she is also a person with disability, and it is not possible on her part to contest the aforementioned proceeding at Sibsagar. And under such circumstances, Mr. Das has contended to transfer the title suit M number 142 of 2025 pending before the Court of Learned District Judge Sibsagar to the Court of Learned Principal Judge Family Court Gauhati. Kamrup M, Gauhati. Mr. Das further submits that there is a requirement of staying further proceeding of the TSM case number 142 of 2025 as on account of non-appearance of the petitioner, the learned court may proceed to hear the matter ex parte against the present petitioner. And therefore, Mr. Das has contended to stay further proceeding of the TSM case number 142 of 2025. The submission of Mr. Das needs further consideration at this stage, and notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post, speed post with AD and also by usual process within a week from today. and pending further consideration. Further proceeding of transfer on TSM case number 142 of 2025 pending before the Court of Learned District of Sibsagar stands state till returnable date list after 4 weeks.
Item two,
Much obliged.
Lordship. This has been prayer made against the ex parte order passed by the Honorable Civil Judge Senior Division Number 1 of Kamrup Metro.
Okay, let notice go at this is. Heard, Mr.
ML Pandit.
M.L. Pandya, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 16/1/2015 and 18/11/2025 passed by the learned civil judge senior division number 1 Kamrup M. Peruse the petition and the documents placed on record, and also peruse the impugn orders dated 16/1/2015 or 2025.
25 Lords. 2025.
Oh, what is there in your petition? Cause title? See,
It is 16/1/2025.
16/1/2000.
2025 and 18/1/2025.
Is it?
Yes.
You see what you have written in this petition?
But in mine it is 25.
Eighteen 11/2025. Let notice be issued to the passed by the learned civil judge senior division number 1 Kamrup M. Let notice be issued to the respondent return. No, it is to be noted here that by the impugn order dated so and so, the learned civil judge senior division number 1 Kamrup M has rejected the petition filed by the petitioner for setting aside the ex parte order dated 16/1/2025. Let notice be issued to the respondents returnable in 4 weeks. Respondent returnable in 4 weeks. Step be taken by registered or speed post also, and also by usual process written from today. List the matter after 4 weeks. Mr. Pandya, learned counsel for the petitioner, submits that an inadvertent mistake crept in the cause title of the petition, wherein the date is mentioned, impugn order date. Now, date of the impugn order is mentioned as 16/1/2015, and the same, according to him, ought to have been 16/1/2025. Mr. Pandya is granted liberty to file an interlocutory application for making necessary correction of the aforementioned date. List after 4 weeks.
item number,
Obliged, Lords.
May I please your lordship, this is a contempt petition, order and judgment copies annexed, I have annexed, passed by the additional district judge 1, for in misreference case, so and so for, release of payment and hence payment. But the contemptor has not complied with.
Heard, miss? Your
L.
name?
Thakur. L. Thakur.
L. Thakur, learned counsel for the applicant. This application under section 10 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India. is preferred by the applicant, namely rationale, for non-compliance of the common judgment and order dated 22nd of May 2025, passed in Miss reference case number 26 of 2000 and Miss reference case number 30 of 1999, arising out of LA case number 27 of 1995, passed by the Court of Learned Additional District Judge number 1, Kamrup M. Gauhati. Where is the petition? And the documents, lesson record, and the judgment and order dated 22/5/2025. Passed in Miss reference case number 26 of 2000 and also the Miss reference case number 30 of 1999, arising out of LA case number 27 of 1995. Passed by the Learned Additional District Judge number 1, Kamrup M. Gauhati. Let notice be issued to the respondent returnable in 4 weeks, slipped by speed post and also by usual process within a week from today. List after 4 weeks.
Item number 4.
May I please, Your Lordship? Can this matter kindly be taken on Friday, Lordship? Can this matter kindly be taken on Friday, Lordship?
Why?
My senior has some personal difficulty, Lordship.
Who is your senior?
Mr. N.N. Upadhyay.
NN Upadhyay.
Yes, Your Lordship.
You see, today only you will issue notice. You can appear. Heard, Mr.
My name is B.B. Kakoti.
Learned Counsel for the applicant. This application under section 12 Act 1971 read with Article 215 of the Constitution of India. Read with Rule 9 of the Gauhati High Court Contempt of Court Rule 1977 is preferred by the applicant for willful and deliberate violation of the order of this court dated 16/10/2025, passed by this court in CRP IU number 432 of 2025. Where is the petition and the documents placed on record, and also where is the order dated so and so so and so, passed in CRP IU number 432 of 2025. Let notice be issued to the respondents returnable in 4 weeks, slipped by speed post and also by usual process within a week from today. List after 4 weeks.
Deeply obliged.
Item 4.
Orders?
Item number 13. Adjournment.
Number 9. Oh, thank you.
Item 14. 14.
If we can. Okay, ready to do.
Item 16.
May it please, Your Lordship. Say we have taken steps upon the respondents. However, the same is not reflected in the office note. Because the office note is of 26/2 and we have taken steps on 27/2.
Why this a miss case?
Your Lordship, for restoration, readmission of the CRP, Your Lordship.
Okay. Yeah, delay is yet to be condoned.
Lordship, we have taken steps in the delay condonation petition.
You have taken a step on who is that?
27, Your Lordship.
27. Okay. Heard, Mr. Buragoy, Learned Counsel for the applicant. Referring to the office note dated 26/2/2026, Mr. Gohai submits that he has taken step upon the respondent on 27/2/2026. Accordingly, it is provided that rest is unless the matter after
2 weeks, Lordship.
2 weeks, awaiting service report upon the respondent. Respondent opposite party.
Deeply obliged.
Item 17.
My lord, I am sorry, my item was 5, my lord.
I was my fault. Oh, may I please? So in this matter, my lord, the petitioners seem not to be interested in taking steps. I have advised as per this honorable court's order as to for taking steps, but they are not cooperating. So I'll have to withdraw my wakalatnama otherwise. I'll take steps for withdrawing wakalatnama. We'll serve a notice upon them. In fact,
My lord,
since they are not cooperating with
petitioners
me.
are in collusion with the respondent number 4 to 7. They are actually the caretaker of the respondent number 4 to 7. There's an execution proceeding. The respondent number 4 to 7 failed to stall the execution proceeding. Then, through their caretaker, the petitioners, they have filed this application before this honorable court, and now they are not taking steps.
So that part I don't know. They are not in collusion so far, as per my instructions, but they are not taking steps.
This is the merit of the case.
Okay.
They are not
Heard
taking.
Mr. O. Laskar,
Mine.
learned counsel for the petitioner, and Mr. M. Dotto for respondent number
I have 1 to 3.
1 to 3. 1 to 3.
Steps were required to
Mr.
be taken
Laskar
for
submits that
4 to 7.
he is going to file an application for according him permission to withdraw his wakalatnama from this case. And he prays for granting 1 week time.
1 week time, mine.
Pair allowed, rest is the matter after 1 week.
Item 18.
I'll have to serve notice upon them, my lord. 1 week time will not be sufficient.
2 weeks then.
Mine.
Item 18.
May I please your lordship? According to office note dated 26/2/26, the respondents has not filed any written objection. They have sought time for filing of the written objection.
You are for the petitioner.
Yes, your lordship.
Heard miss your name, please?
S. Pal.
S.
S. Pal.
S. Pal, learned
Appearing on behalf of Mr. S. Datta, learned senior counselor.
counsel, appearing on behalf of Mr. S. Dotto, learned senior counsel for the petitioner. Petitioner. None appears for the respondent on call. Ms. Pal, referring to the order dated 26/2/2026, submits that the respondent herein have not filed any written objection till date. And even they remain unrepresented today. And accordingly, it is provided that recessal lays the matter for admission hearing after 2 weeks.
Master Blood Lordship.
Item 20.
May I please, Lordship. Lordship, as per direction of this honorable court, my lord, I have filed amended IA 205/2024, my lord. And IA 879 to 25, my lord, has been allowed, my lord, by the order 16/12/2025, my lord.
IA number 879.
Lordship, this is allow, my lord, by the order dated 16/12/2025, my lord, for correction of the cost title, my lord. There is a typographical error, my lord, in
Okay.
place,
This was allowed.
Lordship.
Order क्यों pass करे? সেটা উপর লিখিত দেওয়া হয়েছে 205. Your item
205, my lord.
205 is for
For condonation of delay of 16 days, my lord.
16 days. Yes, no objection.
I have flag mark X, my lord, that is corrected, my lord.
Heard Mr. A. Mubarak, learned counsel for the applicant. And also heard Mr. P. K. Deka, learned counsel for the respondent. Mr. Mubarak submits that this application is preferred by the applicant for condonation of delay of 16 days in preferring connected regular second appeal. Regular second appeal against the judgment and order dated, judgment and decree dated 38/8/2023 passed by the learned civil judge Karimganj, Assam in title appeal number 11 of 2022, whereby the learned civil judge has affirmed the judgment and decree dated 18/7/2022 passed by the learned Munsif number 1 Karimganj in title suit number 104 of 2017. Why you could not file the appeal within the stipulated period?
Lordship, I have stated in paragraph number 9 and 10, my lord.
Paragraph number 9 and 10.
Lordship.
What is the ground?
Due to my lordship, some financial problem, my lord, and there is some
In paragraph number 8 and 9.
9 and 10.
9 and 10.
9 and 10. Mr. Mubarak submits that due to some financial constraint, the applicant herein could not file. No, could not undertake the journey from which place?
Karimganj, my lord.
Karimganj to Gauhati to file the present appeal. And in the process, delay of 16 days occurred. And the said delay is not intentional, rather the same is circumstantial. And under such circumstances, he has contended on, and the same has been explained in the paragraph number 9 and 10 of the application. And under such circumstances, he has contended to allow this application by condoning the delay of 16 days. Mr. Deka, learned counsel for the respondent, submits that he has no objection in the event of condonation of delay of 16 days in preferring the connected regular second appeal. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed in the record, and also the explanation so put forwarded for the delay of 16 days in preferring the connected regular second appeal as explained in paragraph number 9 and 10. And it appears that the delay has sufficiently been explained, and accordingly, the same is then condoned. In terms of above, this IA stands disposed of, and in view of the IA order passed in the IA, the registrar shall register the regular second appeal and list the same before the court as soon as practicable.
My lord. And my lord, consider.
No, I'll serve.
But
Memorable, I will serve.
okay, Mr. Deka, learned counsel for the respondent opposite party submits that he has not been furnished with a copy of the memo of appeal. Mr. Mubarak undertakes to furnish a copy of the same during the course of the day.
Give your place. Give your place.
21.
Thank you.
May please, Honorable.
Yes.
So,
So on the other day, you have submitted the decision of
I
Odisha.
submitted a e-note, my lord. They were that react from Orissa, which held that individual under the relevant section 2 of the RERA Act is also allowed to file against the builder. Then I had quoted, there were some other judgments from Patna. Then that Supreme Court also had Daniel judgment, where in Patna, my lord, the Bihar government has issued a special notification allowing the landowner to file.
Okay.
So that we may have to implement the state of Assam also,
Hmm.
because such notification doesn't exist in the state of Assam. Then in addition, one Kerala High Court judgment I placed.
Hmm.
I referred to para 6 and 8 of that judgment. That judgment was submitted to my lordship by the case. The other case was attached to me, which they have separated.
Mhm.
Those councils preferred to be separate because they have an arbitration proceeding going on at the moment. So they didn't want to have a quick decision here. Their submission was that, their matter will be delayed if my matter is yet to be, notice is to be issued.
Hmm.
So today there can be a twofold order, my lord. One is if the registry can be directed to implead the state of Assam as a party. And secondly, my lord, I can take steps to serve everybody.
Okay, we'll pass the order.
I'm deeply obliged, my lord.
Cover. Next side.
Item 22.
May I please, your lordship, as per office note dated 25/2/26, lordship, service is complete upon respondent's lordship. Service complete, lordship.
Complete.
Yes, lordship, and
You are paying for all the response.
All the response. So one
Okay.
response for 1, 2, and 3.
Okay.
All response.
Okay.
PCR also received, lordship.
Heard, Mr. Your name, please.
P. Sharma.
P. Sharma, learned counsel for the appellant, and Mr. U. Sharma, UB Sharma, learned counsel for the respondents. It is submitted at the bar that service has already been completed and LCR has also been received. And as such, the matter may be listed for hearing. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recessal list the matter for hearing in usual course. This is 26 matter. Rest they will fix the date.
There is IA, lordship, for stay, lordship.
IA,
Yes, lordship.
Matter is already admitted, lordship.
you have no objection.
I cannot stop.
You cannot say, but you have no.
Submission, another time. Lordship.
Hmm.
They are trying to change the national character of the suit. That's
How?
why I need to file a injunction application, lordship. That's why my full submission, I have no objection with the state, but letter may be fixed for, that may be fixed for hearing, lordship.
No. 26 matter. If you file an interlocutory application, we will see.
Okay, lordship.
Heard, Mr. Sharma, learned counsel for the applicant. Mr. UB Sharma, learned counsel for the respondent opposite party. This application under Order 41 Rule 5, read with Section 151 of the Code of Civil Procedure is preferred by the applicant stroke appellant for staying execution of the decree dated 18/11/2025 passed by the learned Civil Judge Senior Division Nalbari entitled Appeal Number 4 of 2024. Mr. Sharma, learned counsel for the applicant submits that connected appeal being RSA number 2 of 2026 has already been admitted for hearing. And the record has also been called for and the same has been have been received by the registry, and the matter has been fixed for hearing. And as such, whether any execution proceeding is filed,
At present, no, lordship.
We have not filed it. Till that, lordship.
and that there is a requirement of staying the execution of the decree till disposal of the regular second appeal. Mr. UB Sharma, learned counsel for the respondent opposite party, however, opposed the petition. It is not in dispute that the connected appeal has already been admitted for hearing and the record has been called for and the same has been received and the case is fixed for, appeal is fixed for hearing. And in that view of the matter, execution of the decree dated 18/11/2025 stands state till disposal of the RSA number 2 of 2026. In terms of above this, IA stands at disposal.
23.
The regular second appeal has been admitted and TCR was called for. So there is no stay of the execution because they have filed a regular second appeal against the judgment and decree passed in the order 21/97/99 petition.
You are for the
I am for
respondent.
the respondent.
Appellant is absent today. None appears for the appellant control. How about Mr. Biswas, learned counsel for the respondent present? List the matter after 1 week. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
24.
May it please your lordship. My lords, respondent number 2 has received the notice and they have entered appearance, but respondent number 1, no AD or unserved notice has returned. So that may be awaited now.
You are for the respondent number 2. Heard Mr.
R. Ghosh.
Learned counsel for the petitioner and Mr. Kakoti. Learned counsel for the respondent. Number 2. Learned counsel for the petitioner submits that as per office note dated 26/2/2026, neither service report nor unserved notice issued to the respondent number 1 returned till date. What to do? You want to take fresh step?
My lords, registry may be directed to submit the postal track record if possible. It may be awaited.
Okay. Registrar shall list the matter after 1 week, awaiting service report upon the respondent number 1. And in the meantime, registrar shall also track the consignment in the website of the postal department and put up one up-to-date office note in respect of delivery of the item. List the matter after 1 week.
My lords, there's an interim order as well.
Interim order passed earlier shall continue.
Obliged.
25.
My lord.
I'm appearing for the respondent.
Respondent.
On the
Service completed.
Service is complete. We have taken all the 3 services as per the
No,
order.
that's all right. If he entered appearance,
Yes.
then there is no question of
That will come up for admission, Lordship. In the meantime, we intend to file affidavit in opposition, Lordship. There is a stay
Okay.
for it.
Heard Mr. Nandi, learned counsel for the petitioner, and Mr.
M. Hassan, Lordship.
M.
M. Hassan.
Hassan,
Yes.
learned counsel for all the respondents. Yes. All the respondents. It is submitted at the bar that service in this matter has already been completed. And as such, matter may be listed for admission hearing. Accordingly, it is provided that registrar shall list the matter for admission hearing after 1 week.
Yes, the date will be fixed, Lordship. A stay is open, operating.
Correct.
On 27 March.
27 March.
Till then, my lord, the execution may be stayed as it is passed in the last order also.
Interim order was passed.
Yes, my lord.
Okay.
It is.
Interim order passed earlier shall continue till 27th. 27 March. In the meantime, learned counsel for the respondents may file their objection petition.
Deep papers.
26.
As per office note, your 5P2, my learned is already appeared.
Appear on behalf of customer number 1 and 2. After inspection, I have no file local number. We'll file local number today.
Ugalodnama.
There is a delay application, you receive only 5 days delay in filing the appeal.
Any objection?
And I should not have all the 5 days.
5 days. Then we can pass the order.
Unlike the method of
Admission.
Heard Mr. N. Sharma, learned counsel for the applicant. Mr. Bhagavati, learned counsel for the opposite party. Mr. Bhagavati submits that he will be filing his power during the course of the day. This interlocutory application is preferred by the applicant for condonation of delay of 5 days in preferring connected regular second appeal. Mr. Sharma learned regular second appeal against the judgment and decree dated
26/6/2018.
26/6/2018 passed by the learned Civil Judge Junior Division number 1 Kamrup M Gauhati in title suit number 69 of 2015.
Your Lordship, order judgment dated 06/09 and 25 2025.
Okay, judgment and decree dated 6/9/2025 passed by the learned Civil Judge Senior Division number 1 Kamrup M Gauhati in title appeal number 47 of 2018, whereby the learned Civil Judge Senior Division number 1 Kamrup M Gauhati herein after Appellate Court, First Appellate Court has affirmed the judgment and decree passed by the learned
Civil Judge Junior Division number 1.
affirm or set aside.
Partly allowed, Your Lordship.
Partly
Initially, suit was dismissed. So respondent filed an appeal. They are the partly allowed. So against that partly allowed, we have appealed.
Partly allowed the decree, judgment and decree passed by the learned Civil Judge Junior Division number 1 Kamrup M Gauhati in title suit number 69 of 2015, while impugn judgment and decree dated 26/6/2018. Mr. Sharma submits that why you could not file the appeal in time?
Because in the relevant point of time, Your Lordship, I was out of station. Because within that period, we had to deposit court fee, required court fee for certified copy. So
Okay.
that could not be deposited on
Mr.
time.
Sharma submits that in which paragraph of your
Paragraph-
application you have
Paragraph
explained?
3, 4, 5, and 6, we have explained. Your Lordship.
3, 4, 5, and 6. So Sharma submits that during the period he was out of station and on account of which he could not deposit the court fee within time. And as such, delay of 5 days in filing the regular second appeal occurred. And the same is not intentional, rather it is circumstantial, and under such circumstances he has contended to allow this application. Mr. Bhagavati, learned counsel for the opposite party, submits that since the delay is only of 5 days, he has no objection in the event of condoning the same. Having heard the submission of learned counsel for both the parties, I have carefully gone through the application and the documents placed on record, and also the statement and averment made in the paragraph number 3, 4, 5, 6. Then it appears that the delay of 5 days is sufficiently explained, and accordingly the same stands condoned. In terms of above this, IA stands disposed of. In view of the order passed in the IA, now the registry will proceed to register the regular second appeal and list the same before this court as soon as practicable. Before the court.
27. Take this one. I have for condonation of delay, my lord. Earlier, my lord.
Notice served.
Yes,
Not
my
served.
lord. Yes, my lord. As per order dated 31/2026, my lord, step was taken, my lord. Speed post as well as usual.
When?
Lordship, 9/2/2026.
Heard, Mister, your name, please.
H.A. Rashid.
Learned counsel for the applicant. Office note dated 26/2/2026 indicates that neither ID card nor unserved notice issued to the opposite party stroke respondent returned till date. Recessal lays the matter after 1 week awaiting service report upon the respondent. And in the meantime, recessal also track the consignment in the departmental website and put up on up-to-date office note regarding delivery of the item to the respondent, issued to the respondent.
Published.
28.
Briefly, I am told respondent number 2, my lord.
Regarding respondent number 1, Lordship, neither ID card nor answered notices has been received till this section.
You go for respondent number 2. Hard Miss
K. Bharali, Lordship.
K. Bharali, learned counsel for the applicant, and Mr.
S.M. Burwa.
S.M. Borwa, learned counsel for the respondent number 2. Office note dated 25/2/2026 indicates that neither ID card nor answered notice issued to the respondent number 1 received by the registrate till date. You want to take phrases there?
Yes, Lordship.
The learned counsel for the applicant submits that she may be permitted to take phrases leave upon the respondent number 1. Accordingly, it is provided that step be taken by speed post and also by usual process within a computing. List the matter after 4 weeks.
Yes. Much obliged.
29.
Met the lordship. Lordship, already this matter has been admitted on 23rd 7/25 and in I am notice issued. My learned friend principal respondent is appearing, Milord, and in the meantime, Milord, execution proceeding they initiated. So may I pray, Milord, to consider my IA 2235 today. And in the meantime, Milord, one another IA we have filed that is 329. If I am not pressing, that may be closed, Milord.
Okay. Mr. P.K. Dekar, learned counsel for the applicant, submits that he is not going to press this interlocutory application. And
329.
thus the same may be closed. Accordingly, taking note of the submission of Mr. Dekar, this IA stands closed.
Yes, Milord. And 2235, Milord.
This is for?
This is for stay of the proceeding, Milord. On 23rd 7 order kindly we have looked, Milord.
So all the
Milord, yes, Milord. So far as regarding rest respondent 2 to 10 is concerned, my learned friend Mr. Loskar, Milord, he took instruction from his client. Their name may be struck off, Milord. 2 to and respondent 1 is the concerned respondent here, Milord. 2 to 10 may be struck down, Milord. Their service not
Yes.
necessary.
And objection on the tracking of that.
heard Mr. Dekar, learned counsel for the applicant, and also heard Mr. M.J. Kadir, learned counsel for the respondent number 1. Mr. Dekar submits that the name of respondent opposite party number 2 to 10
Milord.
may be struck off from the array of this application. As he can represent them.
Milord,
He can.
my learned friend
Will not represent me.
no, their name may be struck down, Milord. Only sole respondent 1 is sufficient here, Milord. He is the concerned
Okay.
respondent.
Maybe struck off from the array of this application as the sole respondent number, no, as the respondent number 1 is the only necessary party in
Yes,
this
Milord.
interlocutory application. Accordingly, taking note of the submission of Mr. Dekar, learned counsel for the applicant, the name of opposite party, respondent opposite party number 2 to 10 are struck off from the array of this application. No, there are some other
2 to 10 are not pro forma dependents, Milord.
performer dependence. Okay. Yes, any objection in staying the proceeding?
Stay the proceeding.
Oh, sorry, staying the execution?
See, they are called my lord and already admitted, my lord. Normally, my lord.
So you have no objection?
My lord,
receipt of the LCR, my lord, the matter may be, my lord.
listed for hearing.
In the meantime, the execution proceeding initiated, so may I pray for consider my that I am not.
Okay.
If my learned friend.
Mr. Deca, learned counsel
Immediately,
for the
LCR
applicant
है, मैं
submits
सबको
that
दिया।
connected regular second appeal
Pending के खिलाफ है।
being RSA number 105 of 2025 has already been received. Has already been admitted for hearing. And that the LCR has also been called for. And in the meantime, the opposite party, respondent opposite party number 1 has already instituted one execution proceeding. What is the number?
Yes, my lord. Execution proceeding number is, my lord. 32 of 25. Yes, my lord. 32 of 25.
32 of 2025. And what is this? That case is pending.
Only notice issued, my lord, I think my.
Only notice
In
issued.
the said execution proceeding notice has already been issued to the applicant hearing.
Why not?
And as such. Now, and since the appeal has already been admitted for hearing, there is a requirement of staying execution of the impugned judgment and decree passed by the learned first appellate court. Mr. Kadir, learned counsel for the respondent, opposite party submits that he has no objection.
Hearing of fixed court.
Accordingly, taking note of the submission of learned counsel for both the parties and also considering the fact that connected appeal has already been admitted for hearing, this interlocutory application stands allowed by staying operation of the title execution case number till disposal of the RSA number 105 of 2025.
Deeply blessed.
In terms of above this, I stands a disposal.
Deeply blessed.
Races at least the RSA number 105 of 2024 hearing as soon as the LCR has been received from
Yes,
the
Lord.
learned courts.
Yes, deeply blessed.
I am for the appeal, my lord. LCR has not been received, my lord. No reminder has been issued, my lord.
Service completed?
Yes, my lord, completed, my lord. Nineteen 2025 office note, my lord.
Heard Mr. Soikia, learned counsel for the appellant. Mr. Soikia submits that in this matter, services already been completed and the trial court record has also been called for, but the same has not been received, and as such, reminder may be issued to the learned courts below for transmitting the LCR without further delay. Accordingly, taking note of the submission of Mr. Soikia, learned counsel for the appellant, it is provided that Justice shall issue reminder to the learned courts below for transmitting the record without further delay. List after 2 weeks.
My lord.
33.
May it please, lord. My lord, by earlier order, it was directed to be listed along with CRP IO 411 of 2025. But it is listed before your lordship alone, along not with this. So that order may be carried out, my lord.
So one contempt proceeding is pending.
Yeah.
And the CRP IO number 411 is tagged with that matter.
My lord.
Therefore, the same could not be tagged with this.
This case is to be taken with that matter, my lord. That was the order.
No, in that contempt case, order has been reserved by another court.
My lord.
So therefore, this matter cannot be tagged with that matter.
No, my lord, order is not, it is to some extent raised in misconception, my lord. This is another case, my lord. Contempt case was list for order, not CRPIO,
No, that CRPIO is tagged with that contempt matter.
my lord.
Therefore,
My lord. So, my lord, that bench is not available, that's all right.
you have
Subsequently,
not taken step upon the respondents.
my lord,
You have not taken any step upon the respondents.
step taken, my lord.
No, no, office note dated 26 to 20,
My lord,
26.
then in that case, my lord, I am to ascertain because we have taken a step. I am to give this number, etc. my lord.
Till 26 to 2026, no step has been received by the registry.
My lord. My lord, as I remember, my lord, it was given, but I am to ascertain. my lord.
Heard Mr. MSek, learned counsel for the petitioner. Office note dated 26 to 2026 indicates that step has not been taken. No, step has not been received by the registry till date. Mr. Sheikh submits that he has already taken step. Accordingly, it is provided that Mr. Sheikh shall obtain instruction, and if no step has been taken in the meantime, he shall take step upon the respondent as directed by the order dated 13 to 2026. Place the after 4 weeks.
Pavlaji.
Timing address 13.
Lastly, can I peruse the order dated 6/2/2026? On that day, Lordship, standing counsel, finance, they have submitted a letter dated 5/2/2026, whereby they have sought some document, Lordship. Accordingly, the director, Limited Education on 24/2, Lordship, has submitted all those tax rates, Lordship, the court order minus of the SLSC, along with the total financial implication with effect from 1/1/2021 to 28/2/2026. That was forwarded to the finance. Now, finance again saw some further documents and along with a copy of the petition also. So that is 34 within a day or two. So we have already submitted the checklist and total implications, financial implications to the finance for creation of the post has to be created. Now we have already recommended his case. Only now finance has to create the post. Second page, is the for DO.
Heard Mr. Z.U. Ahmed. R. Islam, learned counsel for the petitioner, and Mr. Sisti, learned counsel for the contender. Mr. Sisti, learned counsel for the contender, has produced one letter dated 27 to 2026 of the Deputy Secretary to the Government of Assam Department of School Education, addressed to the Director Elementary Education, requisitioning few documents, including copy of WPC number 6697 of 2021. And he also submits that the said documents will be transmitted to the finance department. Already
Director will submit to the government.
Yes.
Yes, government, and government will then submit to the finance department.
When you are going to submit it?
I have inquired to the director within the day or tomorrow, today or tomorrow.
Mr. Sisti submits that
It's a holiday, that's why this
today
week,
or by tomorrow.
No, tomorrow is a holiday. It's week.
Within the present week, the Director Elementary Education will submit the requisite document to the government for onward transmission of the same to the finance department.
Yes, sir.
And he tries for listing this matter after
Finance will take some time. 2 weeks, Lordship, will apply the
After 2 weeks.
Yes.
After 2 weeks. Fair allowed, recusal is the matter after 2 weeks. The letter produced before the court today shall be marked as annexure.
Apply your
Annexure B and be tagged to the record. In next item,
Kindly fix the matter, my lord.
when? Okay.
After 2 weeks, kindly fix. Here also on the last occasion, we have already placed that instruction where the post has already been, the director has already submitted to the government for creation of post. They have already been recommended. So post is been created now. Only my delivery instruction today is that concurrence from the finance department is awaited. So once, as soon as that concurrence is received, Lordship, formally that appointment letter will be issued. So
No, that's all right, but when you are going to receive the concurrence?
Lordship, this is only because of some delay, because the director is on a child care leave, that instruction is already there. So Lordship will fix after 3 weeks. In the meantime, perhaps that finance concurrence will also be received. And as soon as the concurrence is received, because the recommendation has already been done, and post has been already been directed to be created. So only concurrence from the finance department is awaited. Once that is received, formally that appointment will be issued. This is my.
Heard Mr. Islam, learned counsel for the petitioner, and Mr. P.N. Sharma, learned counsel for the contempt notice. Mr. Sharma submits that.
Instruction, the last one is 5th February. That's right, yeah.
Submits that the matter is pending for receipt of concurrence from the finance department, and as soon as the concurrence is received, the director will issue the appointment order, and he press will list in the matter after 3 weeks. However, considering the fact that the matter is pending since the year 2024, Mr. Sharma is granted 2 weeks time to obtain up to date instruction and apprise this court about the status of the financial concurrence. No, about the status of the concurrence to be accorded by the finance department. This is the matter on.
On 20 March.
Obliged.
Thanks for admission. Number 5.
My lord, the petitioner read for amendment of the plaint, and the petition is at page 35, my lord. And that was rejected. And against that rejection orders, this petition is filed, my lord. The thing is that, my lord, the petitioner want to amend the one DAG number. That DAG number is written wrongly. Instead of 196, but DAG number is written 196. And it was revealed at the time of examination of Latmandal, my lord. And the
No, at the time of passing the impugn order,
my lord,
dated 16 to 2023,
yes,
at what stage the case was pending?
my lord, the finding is that it is
No. At what stage the case was pending there?
stage is the cross-examination of PWs, my lord.
Cross-examination of
PWs.
So once the trial is started, whether court can allow amendment?
That can be allowed, my lord.
That can be allowed?
Yes,
under some circumstances?
Yes, my lord. It is due.
Then, when you have filed a written statement in that case,
No, I filed a plaint. my lord.
you are the plaintiff
Yes,
there.
yes, my lord.
Okay. When the other side file a written statement,
Written statement is, my lord, it is there. I will have to see. Page 23, 20, 20. Twenty-eighth day of July 2014.
on who is that? 20?
My lord, 28th July 2014.
2014.
My lord.
So after filing of the written statement by the other side,
My lord.
you came to know that there is a requirement of changing the patta number.
No, my lord. Actually, the dispute is in respect of a path, my lord. The path is situated.
No. You have filed the application for amendment of the schedule.
Schedule, my lord.
Yes. Dag number and patta number.
Dag number, a boundary dag number is written wrongly, my lord. And this suit land is a path, my lord. And that part, instead of, my lord, 116, it is written as 196, my lord. I have obtained a certified copy of the trace map. And that trace map is supplied by the authority, my lord, revenue authority. And in that trace map, it is wrongly written. And I have written the tag number from the trace map of the certified copy. And while lot model came, and on examination of the lot model, he stated that yes, it is that certified copy is wrongly written. Instead of 196, it is written as 116. It ought to have been 116, but it is written as 196. And I put the tag number in the plane from the certified copy of the revenue authority, my lord. And he admitted that this certified copy is wrong. That is my contention.
No,
Here-
that contention, all right. But you see, you came to know about the same,
my lord,
after filing of the written statement.
Not my lord.
When?
When I paid for a commission, my lord. Commission under order 26 rule 9. In that report, my lord, it is revealed that the tag number is wrongly written, my lord. That report is there.
When did you file that application?
Which one, my lord? Commission, my lord.
May it please your lordship. My lord, we had sought appointment as a guardianate litigant in respect of a defendant, my lord. That prayer was rejected, which is why we are here, my lord. If your lordship may kindly have page 14 for a moment. Page 14, your lordship finds the array of parties. They're all descendants of late Kaliram Medhi. And the main defendants are defendant number 1, Bondona Medhi, and her own daughter is arrayed as defendant number 2, Bornali Medhi. Now, if your lordship may, so mother and daughter were arrayed as defendant number 1 and 2 respectively. Now, if your lordship has the written statement filed by the mother at page 30, my lord.
Page 30.
30. 30 is the written statement filed by the mother, my lord. And on the following page, at page 31, your lordship will find a disclosure regarding the daughter, my lord. She says, my lord, at para 4, that the defendant number 2 is mentally retarded and abnormal, suffering from schizophrenia and incapable of defending her interest in the present suit. And as such, without appointment of guardian, the suit cannot proceed, my lord. So that was a specific plea that was taken. Now, despite that, the suit continued, and it is much later that an application was filed at page 55 by the plaintiff. Lord, in the meantime, what had happened was the mother also died on 2/12/2020. So she files a written statement where she says that my daughter is mentally unsound, and she subsequently dies on 2/12/2020. 2/12/2020. So the defendant number 1 has died by this time, and the defendant number 2, who was said to be mentally unsound, is unrepresented through a guardian, my lord. That is why at page 55, your lordship finds that the plaintiff for the first time makes an application, and in that application, at para 3, the defendant number 1 also filed a petition under 32, para 3 of that page, my lord, page 55. The defendant number 1 also filed a petition under order 32 read with 151 of the Code of Civil Procedure on 1/9/2016, praying to appoint the defendant number 1 or any other person as a guardian of defendant number 2, and the honorable court was pleased to appoint defendant number 1 as guardian of defendant number 2. 4, the defendant number 1 died on 2/12/2020, leaving the defendant number 2 as sole surviving heir and representative. That as the defendant number 2 is mentally retarded and cannot represent herself in the instant suit, thus it has become necessary to appoint one guardian ad litem to represent her in the instant suit. So this fact is brought out that the natural guardian herself is no more. So therefore, an application to appoint a guardian ad litem. Now at page 58, annexure 4, your lordship finds the order passed by the Learned Court of Civil Judge number 1. Well, Lord, the last but 4 lines in the backdrop. Last but 4 lines, the sentence begins with in the backdrop. In the backdrop of the petition filed by the plaintiff, this court deems it fit and proper to direct the plaintiff to submit the name of a person who may be appointed as a guardian of defendant number 2. The plaintiff shall take steps accordingly, fixing so and so for steps by the plaintiff. Lord, curiously, the court says that ask the plaintiff to submit suitable names so that a guardian ad litem can be appointed, my lord. Now, on the following page, your lordship will find a will. Now, the defendant number 1, the mother of the defendant number 2, was conscious of the fact that her daughter was mentally unsound, and therefore she had made a will at page 59. And whereas the first recital, I married to Surendranath Medhi since deceased, and from our wedlock, one daughter was born, namely Bornali Medhi, and my said daughter for a long time is suffering from schizophrenia, a psychosis marked by introversion, disassociation, inability to distinguish reality from unreality decision, and there is no hope for her recovery from the disease, and my daughter is living with me. My husband died on so-and-so, leaving behind me and my daughter as his sole legal surviving heir. Now, at page 62, your lordship will find 2 executors are appointed.
Page
62. Para D, my lord. For execution of the will, I hereby appoint Rajesh Medhi, son of so-and-so, and Kinshuk Chaudhary, son of so-and-so, as executor with right to so-and-so. Now, the properties at page 63, your lordship will find there's a stipulation whereby this particular will, a trust was also created. In fact, there's a different trust deed. Clause 2 at page 63, that my said executor after my death will transfer the aforesaid flat in the name of my above named daughter Bornali Medhi, and after her death the said flat and the bank accounts will be bequeathed to the trust which I have created by a deed of trust under the name and style of Surendranath Medhi Charitable Trust. Now, at page 67, your lordship will find the trust deed itself. So she mindful of her daughter's situation, she creates a trust deed. She creates a trust, I'm sorry, and there she again appoints Rajesh Medhi, Niranjan Deka, Arvind Nahata, Bhikhari Jha, and at page 68, Kinshuk Chaudharis to be trustees. So different annuities are devised to take care of the daughter, Malad. So Rajesh Medhi and Kinshuk Chaudhary, both of them are executors to the will and also trustees of that particular trust, Malad. After this, Malad, after coming to know about the litigation that is pending, at page 83, your lordship finds Manoj, these two gentlemen, Manoj Rajesh Medhi and Kinshuk Chaudhary, approach the Honorable Court and express their willingness to act as guardian ad litem since they were also appointed as trustees and executors. And they make a prayer at page 83 to appoint them as guardian ad litem in respect of this particular suit, Manoj. Now, Manoj, the Learned Court of Civil Judge number 1 at page 94 takes up this application for disposal and discards the application by this order impugned dated 3/6/2024. And the main reasoning your lordship finds at page 96, my lord. Para 5, my lord. If I may just summarize, the basic reasoning of the court is that since this will is not probated, so therefore I cannot take cognizance of it. And therefore, without going into the question whether the will is genuine or not, I cannot really appoint these two persons as guardians ad litem. And at page 97, the petition is dismissed. And once again, the court asked the plaintiff to suggest names of advocates to be appointed as guardian ad litems. Page 97. Let the advocates whose name have been suggested be present before the Honorable Court, so and so. And consequently, the name suggests, para 7, my lord, if I may read this. Therefore, considering the aforesaid discussion, this court finds that the prayer of the petitioner appears to be not tenable since it suffers from a lack of merit. And accordingly, the petition number so and so stands rejected. And consequently, the names suggested by the plaintiff side are required to be considered for holding an inquiry to ascertain the feasibility of appointing a guardian ad litem. Para 8, let all the advocates whose names have been suggested be present before this court positively on the next day, inform all concerned, my lord. So this is the order under challenge, my lord. Now, the basic challenge to this order is, my lord, my lord, the court sort of relied more on the plaintiff, the adversary, to procure names for them, so that they can suggest names to appoint a guardian in respect of the opposite party. That prima facie appears to be not in the interest of the person of unsound mind. That's number 1, my lord. Number 2, my lord, the basic ground for rejection is that the will in question has not been probated, so these names cannot be considered, my lord. My lord, the will per se may not be probated, my lord, but that is a requirement. I'm not claiming any benefit. I'm not claiming any right as executor or beneficiary insofar as the will is concerned, because only then section 213 perhaps will come in. I'm just saying that we were already appointed as trustees. In fact, one of the applicants was a cousin, my lord, of the person with unsound mind. And the defendant number 2 is also in my custody, in our custody, in the custody of these trustees. So given that they are related, given that they in any ways have custody of the defendant number 2, and given that they were the natural choice of the natural guardian also, the applicants were best suited to be appointed as guardian ad litem, because a stranger advocate may not perhaps have the acquaintance or may not be conversant with the facts of the case, and therefore to best defend the case of the defendant number 2, my lord, these persons were very ideal to be appointed as guardian ad litem. Now, if your lordship will kindly have the provision on the CPC. Your lordship has order 32, my lord. My lord is aware that the same rules apply for a person with mentally with a person of an unsound mind and for mind.
Rule?
Order 32.
Rule?
Rule 3 is where first the Rule 3. So these are rules for in respect of minors, my lord, but Rule 15 says that same rules will apply also in case of persons with unsound mind. If I may draw your lordship to that rule, first of all, Rule 15 is that rule, my lord. Rules 1 to 14, except Rule 2A, shall, so far as may be, apply to persons adjudged before or during the pendency of the suit to be of unsound mind, and shall also apply to persons who, though not so adjudged, are found by the court on inquiry to be incapable by reason of any medical infirmity of protecting their own interests when suing or being sued. So the persons of unsound mind are basically treated as minors. Now, Rule 3, of course, is talking about the core power of the court to appoint a guardian. My lord. Now, the relevant rule, the most pertinent rule would be Rule 4, my lord. Any person, sub-rule 1, my lord, any person who is of sound mind and has attained majority may act as next friend or minor or as his guardian for the suit, provided that the interest of such person is not adverse to that of the minor, and that he is not, in the case of a next friend, a defendant, or in the case of a guardian for the suit, a plaintiff. So Rule 1 is very clear. Any person is capable of being appointed as a guardian. The conditions are he himself has to be of sound mind and a major. Number 2, his interest shall not be adverse to that of the person concerned. And number 3, he should not be a plaintiff if you're seeking appointment as a guardian of ad litem of a defendant, and he should not be a defendant if you're seeking appointment as a next friend of a plaintiff. So sub-rule 1 of Rule 4 is very clear. Any person qualifying these conditions is capable of applying. So that is where, first thing first, the court must, in my respectful submission, fell in error that I don't need a will. Even if I did not have a will or the trustee, I could have anyways applied.
No, any person may include the advocates also.
Yes. Now I'll come to that. Advocate, yes, my lord. So other sub-rule will now make it clear. If I may just read the other sub-rules. 2. Where a minor has a guardian appointed or declared by competent authority, no person other than such guardian shall act as the next friend of the minor or be appointed his guardian for the suit unless the court considers for reasons to be recorded that it is for the minor's welfare that another person be permitted to act or be appointed as the case may be. I'll come back to this rule, Manoj, because there's another proceeding also. So rule 2 is basically saying if there's already an appointment of a guardian, the courts will generally stick to that. 3. No person shall without his consent in writing be appointed guardian for the suit. This is a fine, my lord. The consent is required. 4 is very important, my lord. Where there is no other person fit and willing to act as guardian for the suit, the court may appoint any of its officers to be such guardian and may direct that the cost to be incurred by such officer in the performance of his duties as guardian shall be borne either by the parties or by one or more of the parties to the suit or out of any of the fund in the court in which the minor is interested or out of the property of the minor, and may give directions for repayment or allowance of such costs as justice and the circumstances may require. Now, when this rule 4 is actually what the power to appoint an advocate as an officer of the court. Now, rule 4, the starting phrase is very important, where there is no other person fit and willing to act as guardian for the suit. So, sub-rule 4 is the residuary provision. If the court finds that there is no other fit person and no other willing person, only then it appoints an officer of the court, which could be an advocate in terms of sub-rule 4. So sub-rule 4 would therefore come as the last resort, if I've understood the scheme correctly. First is to see whether there's some fit and willing person. If there are no fit and willing persons, only then advocate or an officer of the court is appointed. So the court did not say that I am fit or I am not unwilling to act as a guardian. The court merely said that I will not appoint you as a guardian because your will is not probated, which is fundamentally wrong given the purport of rule 1. And secondly, the court must resort to appointment of an advocate or an officer of the court only if it satisfies the first part, that there is no other person. My lord, I believe the reason is simple, because a random advocate or an officer of the court may not be aware of the facts and circumstances. So unless he is conversant with the facts and circumstances, he will not be perhaps able to defend the interests of the minor to the best of his capacity, because only family members will know. Now, I am a cousin, my lord. She is already with me, my lord. So I will be best suited for the job, and which is why I believe sub-rule 4 makes it clear that only in respect of other, when there is no one other person available, only then an an officer of the court is appointed. Now, my lord, coming back to sub-rule 2, my lord, I'm not sure how much it will apply, but if I have understood sub-rule 2 correctly, that if a guardian has already been appointed by a competent authority, my lord, that same guardian should be appointed, my lord. Here, my lord, if I may draw your lordship's attention to page 105, my lord. In fact, in the same family dispute, there was a probate proceeding also pending, my lord, before the Court of Additional District and Session Judge number 2, my lord. But
And the trial court will consider the same in accordance with law.
without this order.
Which order?
My lord, the order dismissing my application coming in the way. My lord, trial court will also consider afresh.
Since this order was passed without consideration of those annexers, which are not placed before the trial court, we set aside the order. We interfere with the order. This order, the order impugned before this court.
This order cannot be set aside because
Why?
no illegality.
No. Unless
The liberty can be given to the petitioner to file afresh. But this impugned there is no illegality.
Unless we interfere with the impugned order, how can we remand the matter to the trial court?
No, your lordship can give a rider to them, to the impugned orders.
That will create difficulty.
That will never create difficulty.
I'll explain.
They do not get difficulty. These orders will remain. And they can file an additional application if you receive permit to file the application. And the matter for appointment of guardian has to be decided at first. Then the trial court is bound to do that.
No. If the trial court find the case in their favor, then
My lord, you see, you also can see. There is no illegality and irregularity of the. No, why this or my point is this, they should remain. They have the right to get application.
Lord, I would have considered to that, my lord, just one point, my lord. This order is on the face of it illegal, my lord, with utmost respect, because it has not taken note of Rule 4 at all. Rule 4, it has absolutely lost sight of, my lord. Other than that, what other illegality, my lord, I'm conceding even otherwise, I'll go back to the trial court, my lord. There's no difficulty with that, my lord. But unless this order is set aside, which is otherwise completely in conflict with Rule 4, reading of that rule shows there is no finding to that effect. So that itself is a sufficient ground to interfere, my lord. Secondly, my lord, why did the court bring in 213, my lord? I am not claiming a right as a beneficiary or executor of the will. I am only saying I was chosen by the natural guardian, so therefore should be considered for appointment. My lord, just one last thing, my lord. My lord, practicality also your lordship will see, my lord. That unsound person is in my custody. Some ABC advocate is appointed, my lord. Tomorrow that person has to be produced as a witness, probably. Tomorrow written statements, evidence has to be filed. How will that learned advocate even know what is happening, my lord? And on top of that, she's schizophrenic, my lord. How will she give instructions to that lawyer? And so therefore it becomes very easy for the other side, my lord, because she will not have the adequate representations when there is a random, there's some learned advocate who is appointed. He will not know anything because this person cannot instruct. He doesn't have prior information about the facts. So naturally that person who is known to the family, who is chosen by the mother, who is in custody of the person of unsound mind, naturally he will be best equipped or suitable for that job, my lord.
okay, we'll pass the order.
Obliged.
The advocate's knowledge and integrity should not be.
No, integrity I'm not questioning. I'm saying that he will not.
Because advocate have a knowledge because he is.
Well, tomorrow, if I'm appointed as someone's guardian ad litem, I do not know. To conduct the trial, I concede it will be very difficult for me on my part. If I don't know anything about the family affairs. A trial that too.
Okay, you go and file an application there.
My lord will give me that liberty and set it interfere. Obligement.
Oh, sir.
Please, your lordship, in this matter, engage counsel is annual, my lord, to do. So time may be given.
Engage counsel
Is annual, my lord.
Annual. Who
He's
is the
suffering
engaged
cold
counsel?
and cough, my lord.
Pardon?
He's suffering from cold and cough, my lord. That's why.
No, who is the counsel?
He's a D. Mohanto, my lord.
D. Mohanto.
Hi.
Yes, Mr. Mohanto. No, that's all right. But when we can fix the matter?
Well, that is well, lordship will go through the last order, that is on 32, my lord. So on that day, there was a observation was there, by which today was fixed for the final disposal of the matter. Because otherwise the revision petition is not at all maintainable. I will come on later on this matter. Lordship will think that if some grounds are there.
Okay.
So definitely, my lord, on short date may be given the fixed.
Okay. Heard, Miss?
B. Hazarika.
B. Hazarika, learned counsel appearing on behalf of Mr. D. Mohanto, learned counsel for the petitioner. And Mr. P. Mohanto, learned counsel for the respondent. Ms. Hazarika submits that conducting counsel Mr. D. Mohanto is unwell. And on such counts, say price for listing the matter after a week.
After 20. After 20, my lord, any date may be given, my lord.
20, no.
After 20. After 20,
after 32.
After 20, any date may be given.
Okay. We are allowed to list the matter on 25th March. Okay.
Obliged.
If this matter may be taken up on some other day. Why? Another case has been taken up. Okay. Okay. Mr. Verdas, learned counsel for the petitioner. Press for listing the matter on
23rd, madam.
23rd of 23rd of March. Pair allowed. None appears for the respondent on call. List the matter after on.
Item 9.
May please, your lordship. By this petition, we have challenged the order dated 25/9/2024. Your lordship will find that order is at page 26, lordship, by which the whatever lordship the petitioner has claimant filed a petition under lordship claim petition under Motor Vehicle Act, lordship, for a vehicular accident, lordship, and the along with the same petition, lordship, the petitioner also preferred a petition under section 5 of the condonation of delay, lordship. That petition was rejected, lordship. Your lordship will file.
Is there any provision for condonation of delay in the new act?
No, if there is a 166(3) of the MP Act, which provides that the claim petition should have been filed within a period of, lordship, 6 months, lordship. Quoting that, lordship, provision, my petition has been rejected, lordship. But whatever, lordship, your lordship dealt in a similar matter, 166(3), and lordship has allowed this petition by holding that in a claim petition, lordship, when FIR was filed after accident, lordship, the limitation will not count, lordship. Yeah, I have already.
Whether such a FIR was filed?
Yes, lordship. After accident, I immediately filed the FIR.
When?
On 10/5/2023, accident occurred, lordship. I lost the 10/5/2023.
10/5/2023.
And I lost the FIR, lordship, on 15/5/2023.
Do you have the copy?
FIR copy, lordship, in the impugnator itself, lordship, the learned trial court has, yes, lordship, I have annexure 10. Annexure, lordship, 1, page 10. In the impugnator also
Whether any case has been registered upon the same?
Yes, lordship. Registered at Borpothar PS case number 25/23.
Borpothar PS case number 25 of
23, lordship.
2023. And whether any accident information report was prepared and transmitted to the MSCT?
No, that information the claimant could not gather. They, in the limitation petition itself, under section 5 in the petition itself, stated that they could not, due to some delay in bringing that accident information report, they could not file the claim petition in time, lordship. That is their averment, but they had no knowledge about whether it was sent to the claim petition or claim tribunal or.
And where is the judgment passed by this court?
Paragraph 6 is the your lordship hold. Based upon these two decisions, lordship, your lordship has passed that order, lordship.
Yes, Mr. Soikia.
it appears that they have filed FIR, but after FIR, whether it is registered or not, that is not.
That is registered.
But not still, no, in MSCT also, we have no knowledge, but government will apply the constitution. Government will judgment.
Will apply.
In fact, your lordship,
Then,
while passing this order, your lordship has referred Gaur Mohammed lordship. In that order.
So, as per, so we'll pass similar order like this then. No, you have enclosed the copy of the FIR here.
Yes, lordship. Annexure 1, page 10, lordship.
Annexure 1, page 10.
Page 10 is the type copy of the FIR. Page 12 is the vernacular of that FIR.
Yes, Mr. Soikia, case has been registered.
Yes, MSCT, police case is registered, but whether it is.
Accident information report was registered or not, it is not. Okay, if FIR can be treated as claim petition, then let the tribunal proceed with the same. Okay, we'll pass similar order.
Yes, sir.
Okay.
For hearing under order 41.
Yeah, right.
51.
FIR scattered for us,
Your lordship, last occasion heard the matter. Whether the certified presumption can be drawn on certified copy or not, or whether the sale deed, the contents of that sale deed is required to be proved or not. On this issue, my lord, your
No, content is required to be proved. Yes,
is-
but when the
Certified-
original certificate, original deed is produced, then
then also, my lord, contents required to be proved. Even it is presumed that it is a
30 years old.
document. Then also content is required to be proved. On this issue, my lord, I have got a judgment of this Supreme Court. Paragraph 10 in, my lord, the 2000 Gangama versus Shivalingam, in this case, paragraph 10.
no, is it your case that after drawing presumption,
My lord.
the court has only passed the judgment based on the presumption only?
Only presumption it was passed. Contents of the documents, that was not proved. That is my case. Even suppose certified copy, then my lord, volume book should have been, my lord, brought to proof. That was also not done. Even any witnesses to this to that sale deed, not, my lord, produced. Author, of course, died, but witnesses, scribes, not, my lord, produced. That is my case.
In which paragraph of the judgment the court
Paragraph
has,
10, my lord.
Pardon?
Paragraph 10. I have
No, not in this judgment, in the judgment of the appellate.
Yes, my lord, discussed.
Issue number?
It starts from page 27, my lord.
27
and 28. Paragraph. Sorry, my lord, page. From 29, it starts from page 32.
So the court has observed that presumption is available
Yes,
in favor of the plaintiff.
plaintiff.
And as per section 92
My
of the
Evidence Act or
BSA,
BSA.
the burden shifted to the
Burden
defendant
shifted to
and
the-
you fail to rebut the presumption.
That is,
So what is there to
My-
rebut the presumption?
no presumption, my lord, first the contents must be proved, then my lord, suppose my lord defendant has no case, suppose. Then also my lord plaintiff has to prove his case that sale deed was correct. Suppose.
No, the court never observed that the document has proved the case of the plaintiff.
So
But court say court
what the burden lies upon me.
yes, court has shifted the burden
Shifted the
to
burden.
you.
Cannot be, well, how? He has to prove first his case. Then my lord, onus shifted to me. It is not my burden. I have totally denied the sale deed. That sale deed.
Yes. Okay, we'll see that.
Well,
Heard Mr. Enhock, learned counsel for the appellant. Order reserved.
in 2010 judgment, my lord, paragraph 26, my lord, he decided, even we admit also, then also burden lies upon him to prove. In 2010 judgment, that LIC India versus Rampal Singh, in paragraph 26, I have noted.
Okay.